Hello guys, welcome back to our channel Legal Nexus. In this video, we are going to discuss about natural law. Natural law is one of the oldest and most influential theories in jurisprudence, tracing its root back to ancient philosophy. It is based on the belief that there are certain moral principles inherent in human nature and discoverable through reasons which form the foundation of all just laws. Thinkers like Aristotle and later Aquinas argued that true law is not merely what is written by rulers but what aligns with universal morality and justice. In this topic, we explore how natural law shaped legal thought, its historical development, and its continued relevance in modern legal system. To define natural law, it must be stated there is no anonymity about the definition and exact meaning of natural law, and the term natural law theory has been interpreted differently depending on the needs of the developing legal philosophy. But the greatest attribute of the natural law theory is its adaptability to meet new challenges of the transient society, natural law theory of jurisprudence. There is no anonymity about definition and exact meaning of natural law. In jurisprudence, natural law rules and principles which are supposed to have originated from some supreme source other than any political or worldly authority. It symbolizes physical law of nature based on moral ideals which has universal applicability at all places and terms. It has often been used either to defend a change or to maintain status quo according to needs and requirements of the time. Natural law has been through various stages which may broadly be studied under the following heads: ancient period, medieval period, Renaissance period, and modern period. Based on ancient theories, the Greek thinkers developed the idea of natural law and laid down its essential features. At the time, in Greece, there was great political instability, and it was thought by many that law is made only to serve the interest of strong. But the same situation made some other jurists think in other way. They saw this as an opportunity to develop new universal principles that would tackle and control tyranny and arbitraries of government. Socrates' view on natural law. Socrates believed that as there is natural physical law, there is also natural law. In his concept of natural law, man has his own insight, which make him know of the things whether they are good or bad. It is this insight, according to him, by which a man is able to inculcate the moral value in him. The only way to judge the basis of law, according to Socrates, is man's insight. Through his theory, Socrates wanted to ensure peace and stability in region which was one of the principal demands of that time. According to medieval theories, Aquinas, Chalcolithic philosopher and theologian, moved away from orthodox interpretation of natural law and gave a more logical and systematic theory of natural law. Thomas Aquinas defined law as the obedience of reason for the common good made by him, who has the care of community and promulgated. He divided the law into four stages. They are law of God, natural law, divine law, and human law. Natural law is the part which reveals itself in natural reason. This is applied by human beings to govern their affairs and relations. According to Aquinas, positive law must conform to natural law. Positive law is valid only to the extent to which it is compatible with natural law. Renaissance theories. The Renaissance period marked by a seismic shift in knowledge and societal values witnessed the emergence of groundbreaking ideas and the shattering of traditional foundation. Scientific discoveries challenged established norms and development in commerce birthed new classes fostering the rise of nationalism. This era catalyzed the decline of church dominions, paved the way for theories supporting the state sovereignty. Central to this intellectual revolution were the natural law theories, grounded in the belief that a social contract underpinned society's fabric. Theories of social contract. Social contract theories, fundamental to understanding natural law school during the Renaissance, presupposed a state of nature. Key philosophers shaping this discourse include Thomas Hobbes, John Locke, and Rousseau. Modern theories. The 19th century marked a significant decline in prominence of natural law theories, reflecting the economic and political transformation in Europe. The prevailing spirit of 18th century thought, reason and traditionalism shifted. The challenge posed by the evolving landscape demanded concrete solutions, leading to a departure from individualism towards a more collectivistic outlook. Look, criticism of natural law school. Despite its historical significance, natural law school has not been without its critics. Some argued that the concept of what is natural or rational is subject to cultural relativism, undermining the university of natural law principle. Moreover, the application of abstract moral principles to specific legal rule can prove challenging, raising questions about practicability of natural law in legal system. In most secular societies, there are challenges to the reliance on divine or moral authority as a basis for law, which call for a more neutral and inclusive legal foundation. To sum up, the natural law school views law as rooted in morality, reason, and universal principles that exist beyond human creation. It emphasizes that law should promote justice and reflect what is inherent right rather than just enforcing authority. This school of thought continued to inspire debates on whether man-made law truly uphold the timeless value of fairness and human dignity. Thank you for watching this video. If you like this video, please like, share and subscribe.